Hello, this is Matt on the Moon Lambeau channel. Attorney John Deaton has shared what I believe is his most in-depth breakdown of why ultimately XRP is safe. So yes, of course, the SEC could file an appeal, but he goes into particular detail as to why even if they do that, XRP is effectively likely to be safe forever. And those are my words. I'll share with you his specific words. But I just don't think we have a thing to be seriously worried about. And other than you could apply a small percentage for like a unlikely outlier where the most wacky, bizarre, evil, nonsense thing happens in life, which, okay, fine, technically it's possible. But, we could get hit by an asteroid tomorrow. But it's not the most probable thing. So I don't know if that would be like a 1% odds or 2%, whatever it is. It's very small. And so if you're concerned about what's going to happen, then listen, because Attorney Deaton really broke this down. And this was in response to a perspective from Fox Business journalist Charles Gasparino. And I actually highlighted some of what he said in a video earlier today. So I'm not going to rehash all of that. But Charles Gasparino, no offense to him, I'm not personally attacking him, but he is incorrect in his analysis. He wrote an article in the New York Post, and he doesn't understand a crucial, truly fundamental concept when it comes to securities law about it not being the asset that is the underlying security itself by the nature of existing, unless you go to this what's known as the Securities or Exchange Act definition, which you can Google yourself, and then there's this big list of things that actually are, by the nature of existing, meeting the definition of security. But if it's not listed there, if it doesn't meet that definition, then it's just an asset that could be used in a scheme where transactions, but not the assets, the transactions could be deemed as securities. And so Attorney Deaton also breaks down why he did what he did, and why the judge is right, and then ultimately why this thing, even if there's an appeal, and you're gonna love it. Like, please listen to the end if you can, because Attorney Deaton gets to the coolest stuff, which I think is the appeal stuff towards the end. But he explains why even if there's an appeal, the breakdown of what Judge Torres's highly likely response would be, and the SEC has to know this. It's not going to go well for them if they appeal. It's really not going to go well for them. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so Charles Gasparino shared a New York Post article where he's citing a case unrelated to the SEC v. Ripple case, and then he's critiquing that decision. I'm not going to get into it. It's outside the scope of what has to do with finance or crypto, anything of the sort. I'm not getting into that. But he says that that's a bad decision. Okay, whatever. I'm not opining on that. But you had Dave Weisberger respond to Charles Gasparino, and this is the CEO of CoinRoutes. He wrote to Gasparino and said, "Charles, your legal analysis is wrong. My friend John Deaton can explain why in detail, but the gist is, XRP used to directly fund Ripple is an investment contract. But secondary trades on anonymous exchanges is more like sales of oranges than groves under Howey." And so that's about as succinct as you can get the concept, which another way of saying it is the asset itself is not the security. Asterisk, unless it's listed in the Securities or Exchange Act definition, which I pulled up in a video earlier today, which I'm not going to in this video, but I cited it. It matters. Apparently Charles Gasparino is unaware of this. Attorney Bill Morgan responded and said, "I think that's a good summary of why it is a sound decision." Attorney Deaton responded to that and said, "Been on vacation, but will put out a thread in a few minutes addressing the unfair criticism of the Torres decision. Some of the same folks behind the attack the judge narrative were the ones attacking me prior to the ruling. But Dave, I have to be honest, I'm not sure I could explain it better than you. You summarized it succinctly and beautifully. In fact, I will adopt your comparison here in future discussions." So it's nice that Attorney Deaton got a vacation after this massive win here. Like to hear that. And he did expand upon it. And I'll tell you, even after this massive victory in the SEC v. Ripple case, it's crystal clear that Attorney Deaton hadn't lost an ounce of the fire in the belly here. He is absolutely coming in guns blazing, articulating his position, and he's right here. And so check this out. This is one of the best threads I've ever seen from Attorney Deaton. I absolutely love this. And especially when we get to the part towards the end of this where he goes through the appeal stuff. I mean, it's not literally appeal proof, But that's not what matters even. What matters is what happens if the SEC appeals. Do you know what happens? Well, you're about to find out. It's not good for the SEC. Anyway, check this out. First me, now judge. I've been fighting tribalism, and by the way, I'm going to mention this too. Attorney Deaton did retweet that article I just shared a second ago from Charles Gasparino. So the fact that Charles Gasparino has said the stuff that he said, which I don't think is persuasive, I think that it's wrong on the law and the facts. It seems clear, even though Attorney Deaton isn't, other than retweeting here, he's not explicitly calling out Gasparino. It's very clear that Attorney Deaton believes the same things that I know I do, and probably the vast majority of you out there listening do. So he retweeted Gasparino and he wrote the following. I've been fighting tribalism and echo chamber politics for the last 3 years. In 2013, SEC officials were calling Bitcoin a security. Unfortunately for me and my family, I wasn't aware of Bitcoin in 2013. Where was Max Kaiser when I needed him the most? Laughy emoji. If I had owned Bitcoin in 2013, and those same SEC officials had sued the Bitcoin Foundation and or Bitcoin miners, I would have sued the SEC just like I did regarding its gross overreach related to XRP. In 2020, had the SEC sued Vitalik Buterin, Joseph Lubin, and the Ethereum Foundation alleging today's ETH as a security, including in the secondary market, instead of Brad Garlinghouse, Chris Larson, and Ripple, I would have 100% sued the SEC, just like I did regarding XRP. When I sued the SEC over its grossly overbroad claims regarding XRP, Bitcoin maxis called me the S-word coin attorney. And I'm censoring that, of course, because you might have children's in the background. Oh, you are welcome, parents. Attorney Deaton continues. It didn't matter that my investment in Bitcoin was 10 times larger than my investment in XRP. It didn't matter that I likely owned more Bitcoin than 90% of the maxis. After I filed the motion to intervene in the Ripple case, highlighted Hinman's massive conflicts of interest and appearances of impropriety, and discussed the Ethereum free pass on Patrick Bet-David's podcast and on Fox Business, Ether supporters called me a conspiracy theorist. When Ripple argued the SEC was favoring Chinese technologies, Vitalik Buterin got pissed and claimed XRP lost its right to be protected from government overreach and intrusion. I understand 100% why he got mad, but he didn't say Ripple lost its right. He intentionally said XRP. And there's the tweet on the screen from August 17th, 2022, from Vitalik Buterin. XRP already lost their right to protection when they tried to throw us under the bus as China-controlled, in my opinion. So there you go. Ripple, a developer, an important developer building on top of the XRP ledger, said something that Vitalik Buterin didn't like. Therefore, XRP holders be damned. That's the logic of Vitalik Buterin, everybody. Pretty disgusting. Anyway, Attorney Deaton continues. I was called a wild conspiracy theorist, although all I did was provide a timeline of indisputable facts along with actual documents, e.g., the Joe Grunfest letter, calling into question the SEC's motive and its very different treatment of ETH. Ether maxis said I was a disgruntled XRP holder who was mad he picked the wrong token. It didn't matter that my investment in Ether was 4 times larger than my investment in XRP. The SEC had given ETH a regulatory free pass, and they didn't give a crap about XRP. Period. SEC lawyers argued that I was mad because XRP was suspended on exchanges and that I and others had lost money on our risky gambling bet. It didn't matter that I actually realized a huge gain on XRP, never losing any money on it. SEC threatened me and requested I be thrown off the case. The Bitcoin maxis ignored the gross government overreach because they disliked Ripple and its executives and sincerely believed XRP was a S-word coin because it was pre-mined and the founders had gifted themselves 20% of the 100 billion XRP. And I'll pause and note there, although what Attorney Deaton writes is absolutely correct, I always found that perspective to be completely irrational because they were gifted, 20 again, that amount of the XRP in existence, and it was worth $0.00. The founders and the creators couldn't make XRP be worth anything in the open market. They don't get to choose that. Humans get to choose that if they like XRP. It's always found that to be a very disingenuous nonsense argument, completely irrational. They didn't know it'd be worth anything. They were just doing a thing. And it was the early days of crypto. It's like, chill out. Anyway, Attorney Deaton continues. Objectively speaking, I understood why they felt this way. I stated from the beginning that these were understandable criticisms of Ripple and its executives and worthy of discussion, but it does not excuse the SEC's massive overreach and gross misconduct by senior SEC officials. Before the Torres decision, there was a lot of debate about how she would rule. It was clear to me. I filed suit only 9 days after the SEC's ridiculously overbroad complaint. I said stick to what you can prove under Howey and leave token holders and the secondary market alone. For once, the truth should effing matter. And the truth is that the majority of first-time purchasers of XRP were completely unaware of a company called Ripple that sold software to banks and or that it owned half of all the XRP. Hard stop. Period. And I'll just pause to note, he has proof of that. He has sworn affidavits from XRP holders, and by the way, that was impactful in the SEC v. Ripple case. It impacted Judge Torres, and she cited it in her ruling. So all of you out there that signed up there, you did make a difference, unquestionably. Attorney Deaton continues. The truth is, most first-time buyers bought XRP because it was a top 3 coin and cheap. When they saw that it settled within 3 to 5 seconds compared to 10 minutes to an hour with Bitcoin, and cost only a fraction of a cent to transfer $1 million compared to ETH, they bought more. Even an amazing developer like Jay, so that'd be the creator of Spin the Bits, Jay falls into this category. He bought XRP the first time and had never heard of Brad Garlinghouse or Ripple. He went on to develop Spin the Bits, a payment app that allows you to spend your Bitcoin in 3 to 5 seconds without help from Ripple. And that's why it's so funny to say. I love this, though. The best way to spend and send Bitcoin is to use the XRP ledger. And Spin the Bits facilitates this. And it's just true. It's just a fact. And I love that since I'm pro Bitcoin and pro XRP, I hold both, and I have since November 2017. I love that each asset is helping the other last in terms of long-term viability. They're helping each other effectively because of what the developers have done building on top of both blockchains. I love it. Anyway, Attorney Deaton continues. The truth. There are thousands of XRP holders who acquired XRP for non-investment purposes, moving value on the XRP ledger in seconds for less than a penny, while avoiding the MoneyGrams of the world, or they used the world's first decentralized exchange built within the XRP ledger. Judge Torres' decision was 100% the correct ruling, despite claims that her decision is inconsistent with policy considerations behind the 1934 Securities Act. Show me a Howey factor that considers the level of sophistication of the investors. You can't. I was confident. The truth matters. As the judge found, it's quite difficult to expect profits from the efforts of a company you don't know exists. Common sense also tells us it would be very difficult to enter into a common enterprise with promoters/entrepreneurs you're completely unaware of. Remember, Torres didn't even analyze the common enterprise factor because the SEC failed to satisfy the third Howey factor. And by the way, folks, so this is where it gets extra interesting. If you want to talk about why when it comes to the analysis of this and all the appeal stuff, why we are sitting pretty as XRP holders, this is the part that matters, so sit tight. You're going to like this. I know this is long, but it's a fantastic thread from Deaton, so thanks for sticking through this. Anyway, Attorney Deaton continues. I have news for the Torres haters. The SEC failed to establish the common enterprise factor even less than they established the third Howey factor. Not even close. The SEC was so desperate, it asked the judge to adopt a standard the Second Circuit never has. Even if you believe it's possible to enter into a common enterprise with entrepreneurs you don't know exists, the law in the Second Circuit, per Revic, that's a separate case, Revic case, is that horizontal commonality must exist. So again, folks, there's binding precedent from the Revit case. It states that horizontal commonality must exist in order to satisfy this. And so here's a quote from the Revit case that Attorney Deaton cites. Horizontal commonality is established when investors' assets are pooled and the fortunes of each investor is tied to the fortunes of other investors, as well as to the success of the overall enterprise, end quote. A strict application of horizontal commonality fails. And well, think about it. So there's the quote, it's on your screen, I just read it. Well, why might that fail? Because XRP is fungible and different people are doing different things with XRP and are unaware of other developers in many cases, and same for purchasers of XRP who aren't developers even, it doesn't even almost fit horizontal commonality. Not even close. Of course it doesn't fit that. But check this out, it gets even better. Check this out. Attorney Deaton continues. According to the law, XRP holders are not in a common enterprise with Ripple or each other. Some holders loan out their XRP while others do not. Thus, some holders who choose to stake / loan or collateralize their XRP benefit financially while Ripple or other XRP holders do not. So folks, think about this. If different people are doing different things that lead to different financial outcomes, how could there possibly be some sort of horizontal commonality there? How could there possibly be? Well, by the standards of the law, there isn't. And that couldn't be more obvious. Whereas if you look at what happened with the W.J. Howie Co., back in 1946, that Supreme Court case, everybody that was part of that scheme, everybody that put in, their financial well-being, they were all tied together. That was the point. But with XRP, that's clearly not the case. Attorney Deaton continues. The opposite is true. The Celsius bankruptcy proves the point. Holders who loaned Celsius their XRP suffered financial losses Ripple and other XRP holders did not. The Celsius bankruptcy example destroys any claim of horizontal commonality under existing law in the Second Circuit. Now, folks, you did hear that right. You hear how utterly devastating that is for the SEC, correct? That is fact, whether the SEC likes it or not, and I know they don't, but that is fact. Attorney Deaton continues. In Revit, they owned condo units and, quote, the rents and expenses. Actually, I need to make this one full screen because the show more button popped up. Quote, the rents and expenses attributable to each unit were not shared, but were instead the sole responsibility of the unit owner, end quote. The court held they, quote, could make profits or sustain losses independent of the fortunes of other purchasers, end quote. The court thus found, quote, there are simply no indicia of horizontal commonality, end quote. So there you go. In that case, and this is law, this is legal binding precedent here, there were different circumstances for these individuals. It's the same with XRP holders doing different things with their stuff. Crystal clear. Attorney Deaton continues. XRP holders maintain sole responsibility of their XRP and can make profits or sustain losses independent of the fortunes of their purchasers. The SEC loses the SEC loses the case on programmatic sales and the secondary market in more ways than one. Now this is crucial, listen up. In sum, the Torres decision is very sound. The people predicting Judge Torres will get overturned appear to be sore losers. But now the attack seems to be on this judge who did her job. So folks, think about this. And this is where he's not calling out Gasparino by name, but he started this thread by retweeting Charles Gasparino, who was attacking the judge and claiming that there are poor decisions in other cases. Now, I'm not going to get in the weeds in that. That's non-crypto stuff here. But it is the case that Charles Gasparino is critiquing this judge. And it's interesting that you're seeing more critique from Charles Gasparino than you are from the likes of Elizabeth Warren and such, which I think Attorney Deaton might have mentioned in this thread. I can't remember. I've been reading a lot of stuff today. He might include it in this thread, but he might have mentioned that. But it's a solid point either way. Anyway, Attorney Deaton continues. I remember some XRP holders claiming they were worried or that she was bought and paid for simply because she was an Obama appointee. I commented then that such viewpoints were total nonsense. This case required a simple, strict application of the Howey factors to the facts of the case. Nothing more, nothing less. Judge Torres did her job, and some people don't like it. Too bad. The law won. As my friend Dave Weisberger said, and I shared this quote earlier, he's the CEO of CoinRoutes, XRP used to directly fund Ripple is an investment contract, but secondary trades on anonymous exchanges is more like sales of oranges than the groves under Howey, end quote. Perfect way to summarize the distinction. Just like the people who said Torres wouldn't rule against current administration's SEC because she is a lifelong Democrat and appointed by Obama, attacking her because she was forced by the SEC's regulation by enforcement policy to apply a 1946 test involving orange groves to modern-day blockchain technology, and then arguing the rest is inconsistent with the policy behind a 1934 statute is equally silly. You know how I like to bring facts to a discussion. So let's review Judge Torres' record on appeal, and you all are going to like this. This is really solid. She had 6 summary judgment decisions go up on appeal. All 6 were affirmed. She's had 29 cases reviewed by Second Circuit where she was the sitting judge. 6 of the 29 were remanded in part. The 6 out of the 29 that involved some level of remand, all 6 involved the following issues: standing, application of judicial estoppel, diversity jurisdiction involving non-domiciliary immunity, and pleading sufficient specificity alleging trade secret misappropriation. So, folks, that's not what we're talking about in this case. So, the instances where there were something, where there was some sort of level of remand as a result of the appeal, it doesn't even relate to this case. And then Attorney Deaton says, I would wish the SEC good luck on appeal, but I won't. They need a lot more than luck to reverse Judge Torres. It will be the first time in a summary judgment decision. But even if they won on the issue, she will render the same decision on remand related to common enterprise. So, folks, do you see that? And I love how it perfectly caps off his thoughts right at the end of that thread here. So even if it goes back to her, so there's an appeal and then it goes back to her, she can come to the same conclusion based on a different prong of the Howey test. That's why I was citing towards the beginning part of this video, just wait till you hear this, because when it comes to appeal, that's why, fine, nothing's set in stone, nothing's guaranteed, but I'm just telling you, if it comes down to it, she can use different arguments to come to the same conclusion. Don't you think she'll do that? So this is the law of the land now, and even if there's an appeal that's remotely successful, she's still going to rule the same thing as a result of a different prong. Because she didn't have to get to that other prong yet. But she can, and she will if necessary. I think this is part of her strategy just in case it gets to that point. And so that's why I was saying this is the best breakdown that I've seen from Attorney Deaton on this topic. It's incredibly detailed, which is why it was so long. So thanks for hanging with me until the end of it. But that is fascinating, is it not? So again, I'm sleeping easy. I'm feeling great about this. Right? I hope you are too. And then Attorney Hogan responded to that and wrote, this ruling really is like a fine wine. Just gets better with age. Indeed. So Attorney Hogan seems to agree with this. I'm not a financial advisor. You should not buy or sell anything because if anything I say or write, that would be a very, very, very bad idea. Until next time, to the moon, Lambo.